Good afternoon, everyone. I'm Travis Carpenter, an employment lawyer with Samfiru, Tumarkin LLP here in our Toronto office. Samfiru Tumarkin is one of Canada's leading employee-focused employment law firms. Welcome to another session of our live stream Q&A. We will be answering your employment questions for the next 30 minutes. And if you have any questions about severance pay, workplace accommodations, employment contracts, or any other employment issues, please feel free to put your questions into the chat now, and we will do our absolute best to provide the answers in this session. If by chance you'd like to get in touch with our firm after this session has ended, to get help with your workplace issues or something like that, you can reach us at employmentlawyer.ca, or you can call us at 1-855-821-5900. So there's a couple of things that I wanted to talk about that are just sort of hot pressing issues just to get us off to the start here. But there's a company, Align Technology, the maker of Invisalign teeth aligners. They recently announced a global restructuring plan that includes a large amount of job cuts following loss of revenue and missed projections. So one of the things that I want to talk about is what should Canadian employees, non-unionized, granted, be aware of when looking at a severance package or a severance offer from their company during a restructuring. And one of the things that you should be aware of is that under a restructuring, there's a reason that a company is restructuring. Let's put it that way. In this case, with Align, the major issue here is that this company is not doing as well as they projected in terms of finances. And so one of the things that you want to be aware of is that generally, in this case, these offers from companies might not be as high as they normally would or as fair as they normally would be. And so what I would recommend that you do in a case like this is I would highly recommend that you get your package reviewed. And again, because you could be, depending on a certain number of factors, you could be entitled to severance pay, which could be up for months. As I said, a number of factors. And severance, to be quite clear, can include bonus, commissions, and other various forms of compensation. So again, if you have any questions about your severance package and to see if it's fair, contact our firm and we will do what we can. Again, employmentlawyer.ca. Another question is can employees face legal claims when quitting a job? And potentially, if you haven't provided notice to your employer, what does that mean? And what happens if you don't provide notice to an employer when you leave a company? So the answer to this is sort of twofold, I would say. At least here in Ontario, and I am aware in British Columbia, those employment laws, and for the most part, do not require you to provide notice to your employer. Whether that be, the standard 2 weeks, as people say, giving your employer 2 weeks that you're going to be quitting. However, what I would say, though, is that it's very important that you review your employment agreement, because your employment agreement could have an obligation to provide notice. And if you do not provide notice, there is a chance, albeit a relatively low chance, that your employer could potentially try to, bring a claim for damages for you quitting your job without providing notice. Now, again, I say this is quite rare, and the reason it's rare is because the company or the employer rather is going to have to prove that they have lost something as a result of you doing that, and it is not an easy thing to be able to prove. Let's put it that way. So, I mean, a number of practical considerations. It's always good to just give notice, whether that be for the benefit of your reputation or whether that be, for the benefit of finding a new job. You might need their reference. And to be honest, just morally, it's generally the right thing to do. But if you find yourself in a sticky situation where you're being harassed or things like that, I would say that it's not a necessity that you do so in those cases. But I would say, as a general rule of thumb, there's really no reason to not provide adequate notice. So another question as well, do severance entitlements change during a large scale layoff? And the question to that would be, that would be very similar to the question that I asked or I answered about restructuring. And in this case, as a non-unionized employee, you could be entitled to full severance pay, whether it be due to downsizing, restructuring, or the closure of the business. And this applies to full-time, part-time, and people who are classified as independent contractors who aren't really independent contractors. Now, I see we have a number of different questions coming in. Crash into 2 stated, does an employer have to pay any banked time in lieu if you are laid off? Are there any exemptions to this? Well, bank time in lieu, if you have bank time in lieu, that's a bit different than vacation pay. The company, if you have vacation pay at the time of you being laid off, under certain circumstances, they're going to have to pay out your vacation pay. But that is an important thing to note. Now, if you have bank time off in lieu, that's the same as, basically just having regular time off. It's basically just like having overtime, and they should be paying you any bank time you have off. It depends on if you're laid off or if you're terminated. And this is kind of a bit of a sticky situation. So I would make sure that, it could be a bit of a more nuanced answer. And I would highly recommend that you reach out to us either through our website, employmentlawyer.ca, or by phone, and to have a lawyer look more into that if that's something you need, because there is a possibility that your layoff could constitute a termination, and I would recommend that you reach out. The next question, this comes from, it's me, Lance. I was asked to wear headphones when in the lab at my workplace. I'm on the spectrum, and these help me to focus. I was told that my request would create undue hardship for the company and that I would be a danger to customers, and was then fired. Do I have any rights in this situation? Well, I assume your name is Lance. This is a very good question, actually. I think that there, a little more information would be required here, depending on, what it is that you do for a living. But I would say, by and large, wearing headphones likely wouldn't be an overly large deal. And so one of the things is that, being on the spectrum, in certain circumstances could be classified as a disability. And as we know, here in Ontario, employers have a responsibility and a duty to accommodate their employees. And that is the standard that Lance has correctly pointed out, is undue hardship. They have to accommodate you up to the point of undue hardship. Now, up to the point of undue hardship is not the same as, getting to that point. So a lesser solution could be adequate. But in this case, I think depending on what you do for a living, it could be, I think a little bit more context is required. But the point being, I would say likely in this case, I don't really see how it could be undue hardship. And you were told that you'd be a danger to customers. Again, it really depends on what you do here, but companies do have a responsibility to accommodate. And I would definitely recommend that if you were terminated, there could be some major concerns around that, being terminated as a result of asking the company to accommodate. This could be something that we refer to as a reprisal. And I would recommend that, again, you reach out to have, us get a little more information about your situation, because again, it does matter. The facts matter. So again, you could reach out to us at employmentlawyer.ca. All right. What else do we have here? My company has taken over by an American-based agency, from Steve writes. They want us all to sign new contracts and are changing a number of things. Should we sign this? Any concerns? Well, Steve, this is a very complicated scenario, and I see this quite often. It really does depend on whether or not they are changing things significantly, whether or not they're asking you to give up certain rights. It really does depend on a lot of different things. It depends on whether or not the company, has been purchased, as a whole, or if certain shares have been purchased. Like there's a lot of things that are going on here. And what I would say to you is, in this case, it is always a fantastic idea to have this contract reviewed by a lawyer, by an attorney. And again, I would recommend that you do that, because there could be a number of alarming things, or it could be potentially harmless. So I would definitely recommend you to get that looked over. Again, you can reach out to us at employmentlawyer.ca. Another question here that we've got. Can an employer and insurance entitled to have OHIP and other medical history? That's another question that's similar to another one that I have. Is an employer allowed to request your medical history? So this is a very complicated question, but the major thing that this has to do with is, it's the typical lawyerly answer of it depends. And what does it depend on? Well, so say, for instance, that you are an employee and you are on medical leave, and you've got a number of things wrong with you, and you're trying to get back to work, but the employer, they need to know what is going on, and they need to know the prognosis and the whether or not you're going to be returned to work. And in most circumstances, the employer has an entitlement to know about that. Like, are you going to be coming back to work? What is the prognosis of you coming back to work? They don't need to know things that aren't relevant. They don't need your entire medical history. But when it comes to a specific problem that you may have that's preventing you from working, and is a problem that the company may need to accommodate, I would say in this circumstance that you may be required to provide them with the medical history, and it probably could be in your best interest to do so. Again, as the question is, or as the answer is, again, I would definitely tell you to reach out to us, employmentlawyer.ca, and we could potentially set up a consultation, and we could talk some more about that. So next question: if you have a terminal illness, this comes from Carlos, which does not affect your role, but you are let go, does that affect my severance? So Carlos, it's going to depend in this case why you were let go. If you were let go for terms, if you did something, there was malfeasance, or you did something bad, that could affect your severance. But if you were terminated without cause, there wasn't truly a reason that you were terminated, but the company is trying to sort of hide the fact that they terminated you because you are sick, they're going to have some serious issues on their hands. Because in that case, it could be very well that, the reasoning, it could be what's referred to as prima facie discrimination. And that's a fancy Latin word, but means on its face. And so if you told the company, hey, I have a terminal illness, and then they immediately turn around and terminate you, and your performance has otherwise been fine, that's when the law would step in and say, hey, well, that seems awfully fishy. And if we can prove that even 1% of their decision, of their reasoning, for terminating you had to do with your illness or your disability, then it's going to be quite bad for them, and it could affect damages that you could get. And I would say in that case, again, it is imperative that you reach out to us, employmentlawyer.ca, because a lot of these things are not just one and done. They're very fact specific. In a scenario like that, where there's a lot at stake, I think it's very important to reach out. Another question that we have: I was informed that my employer has decided to change me from a salaried employee to hourly without your consent. Can they do this after your contract was signed? Well, I mean, I would say that it does depend in this scenario on what are they doing in terms of changing your salary? Are they simply just changing you from a salaried employee to an hourly, or are they also reducing your compensation? Because under certain circumstances, it may be beneficial to you to be on hourly if there's certain um, different bonuses for working different hours and things like that. But if the company is significantly reducing your compensation due to the fact that you're now going hourly, this could be what's referred to as a constructive dismissal. And a constructive dismissal is a distinct legal principle that basically means that the company has altered your employment in a significant way, meaning that you basically can consider yourself terminated from your position. Now, in this case, this would constitute, it would be the same as a without cause termination, and you could be entitled to full severance pay, which again, based on a number of different factors, could be up to 24 months. And so if you've signed a contract and you were a salaried employee, and then they've changed to hourly, again, it's going to depend on the circumstances, and there's sort of that threshold of whether it tips us over into significance. And so I would recommend that you reach out. Again, sound like a broken record, but employmentlawyer.ca, and we can see if we can help you out. We have another question here. My sister just returned from maternity leave. She's a director of HR. The CEO she reported was let go during her leave. Her position was eliminated, offered her 2 weeks. Now, I'm not sure whether, Jenny, if you're referring to your sister was let go, or if the CEO she reported to was let go during her leave. Oh, the CEO was let go during her leave. Her position was eliminated, offered 2 weeks. Well, if you're saying that the CEO was let go, I mean, that's just I'm assuming is just a normal without cause termination. And 2 weeks, I mean, depending on how long. Okay, sorry. So your sister was let go the first day back from her maternity leave. Okay, that makes a lot more sense. There are two things on this. The first thing I would say to you is that the Employment Standards Act states that when you are on maternity leave, the company is required to maintain your job, and they are required to put you into the same job you had prior, to going on maternity leave. It states that, and that's very, very clear. Okay. And in this case, it could be that your sister was genuinely restructured, but it's awfully fishy that this happened the first day she came back from maternity leave. It could be that just her job was restructured and they don't have, a similar job for her. That could be the case. But again, as I mentioned before, there is that principle of prima facie discrimination. And that's where in certain circumstances like this, it's basically going to be that, this looks discriminatory on its face. And the company is going to have the responsibility of proving that it's not discriminatory because of this issue. In this case, I would say that very, very oftentimes cases like this it happens more often than we think, rather, because of the fact that there are times where, they've been without that person for so long that they learn how to work without them. But the issue is that there's other times where it is malicious, right? So again, I would tell your sister that, she should reach out to employmentlawyer.ca. We can see what we can do for her. 2 weeks could make sense. It does depend on how long she worked there. But again, I think it's best to have something like that dug a little deeper into. So thanks for that question, Jenny. Next question comes from Scotty Michael. Worked for the same company for 19 years. Boss is over retirement age. My weekly hours now vary from 0 to 40. He turns some jobs down based on what he wants to take on. I need decent hours. Do I have entitlements? Well, I mean, this depends. The issue here, I would say, um, if you've worked for the same company for 19 years and your hours are now significantly tanking and are different than, you were working 40 hours a week and now you're working between 0 and 40 hours a week, and your income is significantly affected by that. I would say to you, Scotty, that it's possible that, you could be considered constructively dismissed, because again, we talked about this principle, and this principle means that the terms of your employment have been altered so significantly, meaning being able to work and receive money have been altered in a way in which you can consider yourself no longer working there. Now, obviously, this principle would mean that you would basically have to, take the company to task, seek severance for that. And in that case, you would basically be effectively almost quitting. It's a bit different semantically, but effectively that's what it would amount to. I would say, it depends. What your entitlements would look like are going to depend on a number of other factors, depending on how quickly it would be for you to get a job and your age. And I mean, obviously you were there for quite a long time, so your severance entitlements could be particularly large. But I would tell you to reach out to us again at employmentlawyer.ca, and one of our lawyers can do a little more digging for you. The next question we have is from Ocean Breeze 2022. Is it common that companies only provide severance if you're laid off or fired? How about if the individual retires? Should they get severance? Now, this is a very good question, Ocean Breeze. I very much appreciate that. Now, one of the things here is, here in Ontario, you do not have any rights to severance if you are the person who resigns. And in terms of retiring, you are now the person who has resigned. So if you retire, you don't have any entitlements to severance whatsoever. Now, that being said, there are certain companies, and it depends. If in your employment agreement, there's a retiring bonus, or the company offers you a retirement bonus, in that case, you could be entitled to it. But as far as the law is concerned, you don't necessarily have an automatic right to get severance if you retire. Now, you said, is it common that companies only provide severance if you're laid off or fired? Well, those are the circumstances in which they would give you severance or are required to give you severance. There's also certain other compensation that you could get if you were, deemed discriminated against, or if the company had, very out-of-pocket conduct, things like that. But as far as, straight severance is concerned, if you retire, there are, at least here in Ontario, there are no obligations to pay severance. Janie has a follow-up question. If they just gave her the 2 weeks pay without having her sign anything, is she able to speak to a lawyer? She was there 6 years. So back to that scenario. 2 weeks is not going to be enough if she worked there 6 years, at least here in Ontario. I would say, even regardless of what her employment contract says, 2 weeks is almost certainly not enough. And so, I would tell her that, she's not under an obligation to sign anything. And I would tell her to speak with us before she does sign anything. And is she still able to speak to a lawyer? If she hasn't signed anything, then yes, she definitely is able to speak to a lawyer. And she has 2 years from the date of her termination to seek an action against the company for wrongful dismissal. But it's always better to do it as soon as you can, in case any hiccups come up, or to get the process started, basically, right? Scotty Michael says, so again, a follow-up question to that: how much time do you have to pursue constructive dismissal after pay is reduced? There was also a change in schedule and availability without your consent. So again, you have 2 years from the date of the constructive dismissal, from the date that things have changed. But also, this does change a little bit, because if months have gone on and you've never objected to that, the company could turn around and say, hey, no, you've actually incorporated this into your employment. You've agreed to this change. So if that happens, I would recommend that you object to this, okay? And I would also recommend that you likely reach out because there could be more at play here. And so that would be the right thing to do. Again, employmentlawyer.ca. Scotty Michael feels like he's waiting for me to get a new job. And so this is something that happens, right? He might want you to quit, right? He wants you to quit. And so that maybe he doesn't have to pay you severance, right? In this scenario, it might make sense to find a job as soon as you can so that you have that money coming in, because he might just wait you out, right? But I would object to this as well. I would tell him, I need these hours, and I would recommend that you do that, and don't just stay silent, because silence is not the right thing in this scenario. And again, you should reach out to us, employmentlawyer.ca. In regards to your retirement comments, what if your employer is pressuring you to retire? So this depends, right? If they're telling you you need to retire, they're doing things that are changing your employment agreement, and they're changing the terms of your employment, and they're making snide comments, and they're offering you a package. I mean, one of the things you could do is you could say, okay, put an offer on the table if you want me to leave. You could try that. But I would make it very clear, if you have no intentions of retiring, I would make it very clear, I have no intentions of retiring. And I would reiterate that. And I would make sure that you do that. Because again, if you have no plans to retire, then you may have a leg to stand on later to say that, I've now been constructively dismissed. If they try to do anything unilaterally, such as demoting you, giving you a different position, or in and of itself, it could be a constructive dismissal. Again, because they've altered the terms of your employment, they've reduced your hours, or they put you in this toxic work environment, or they've been harassing you, things like that. Again, it's pretty specific. There's a lot of nuance and a lot of different factors to consider when it comes to that specific scenario. So BD22, I would definitely recommend that you reach out to us at employmentlawyer.ca. And so that is all the questions that we have today. I just want to thank everyone for joining us today. If you still have any questions, I know there was a couple that I didn't answer at the very end there. If you still have questions, or we weren't able to get to your questions today, please reach out to us at employmentlawyer.ca, or you can join us again tomorrow. Okay, tomorrow, Friday, November 8th at 1 p.m. Eastern time. That's here in Toronto and Ottawa, 1 p.m. Eastern time, for another employment law Q&A with our very own Tilan Celentano. Thank you, everyone, and have a great rest of your day. Thanks for all the great questions. Bye now.